Author Michael Wolff has claimed in a lawsuit that First Lady Melania Trump threatened to sue him for over $1 billion in damages if he didn't retract Jeffrey Epstein-related statements he made about her. Wolff said in the lawsuit that Melania Trump's threat to sue came over statements he made to the Daily Beast and in 3 videos published on social media.
What is going on here? Is Melania Trump now embarrassed by the fact that she made a $1 billion demand against journalist and Epstein chronicler Michael Wolff back in October? Because something very telling is happening in her most recent federal court filings. In the papers she submitted over the last 24 hours, nowhere does she mention the $1 billion demand she made when she threatened Wolff. That omission is not an accident. It's deliberate, and it tells you everything you need to know about how weak her position actually is. Let's slow this down and get into the molecular nitty-gritty details, because the procedural maneuvering here matters. This case did not start in federal court. It started exactly where it was supposed to start.
My lawyers last night, turning the tables and refusing to acquiesce to these threats, went into court in New York and asked for a declaratory judgment.
New York State Supreme Court. Despite the name, that is New York's trial-level court, and it is the proper venue for a declaratory judgment action when a journalist is asking a judge to rule that his reporting does not constitute defamation or libel. Michael Wolff did exactly what experienced First Amendment lawyers do when a powerful public figure threatens them with crushing financial liability designed to chill speech. He ran to court first. Melania Trump did not like that, not at all. And instead of doing what litigants are supposed to do, accept service, appear, and litigate, she spent months dodging service, literal months.
I can subpoena the First Lady, the president of her husband, the president, and anyone else who might shed light on the relationship of Donald Trump and Melania Trump to Jeffrey Epstein.
Process servers attempted to serve her at Trump Tower. They attempted to serve her through counsel. They attempted to serve her at known residences, and she avoided it all. State court judges hate that kind of behavior. Federal judges hate it even more. Eventually, she retained a law firm closely aligned with Donald Trump's legal world, DLA Piper, and they filed a notice of removal. That move shifted the case from New York State Supreme Court into federal court. Now, on paper, removal is allowed in certain circumstances, but let's be clear about what's really happening here. This is not about wanting a neutral federal forum. This is about forum shopping. Melania Trump's real goal is not New York federal court.
But her fundamental argument, her primary argument, is that the doorman got served, I didn't get served. Well, maybe that's because you've been dodging service, bobbing and weaving to avoid it, moving around like you're some sort of MX missile.
Her goal is Florida, specifically the Southern District of Florida, and more specifically, she is hoping the case lands before Judge Aileen Cannon. That is the end game. This is a 2-step choreography. Remove to federal court in New York, then move to transfer venue to Florida, where the odds of drawing a judge sympathetic to Trump world dramatically increase. Anyone pretending otherwise is not being serious. Now we have a Trump-appointed federal judge in New York, Judge Vizcosil, presiding over the early procedural skirmishes, and she is already signaling irritation.
As a fallback is get the case moved from New York to Southern District of Florida, where she may get Judge Cannon. Is this all a ruse to get before Donald Trump's favorite judge?
Not with Wolff's lawyers, but with the procedural mess Melania Trump has created. When Wolff's lawyers appropriately raised jurisdictional concerns, the judge snapped back that she did not need to be reminded of her obligation to evaluate subject matter jurisdiction. That tone alone tells you this judge is not thrilled about being dragged into what looks like strategic gamesmanship. So let's break down the law here, because this matters. Federal courts can hear civil cases in 2 primary ways. One is federal question jurisdiction, cases involving the Constitution or federal statutes. This case is not that. The second is diversity jurisdiction. That means the parties are citizens of different states,
filing in federal court. No personal jurisdiction over me, Judge. Right, because you keep playing whack-a-mole with the process servers. Now, in federal court, that doesn't generally work. First of all, there's ways to obtain from the judge approved alternative service.
And the amount in controversy exceeds $75,000. That's it. Those are the gatekeeping requirements. But diversity jurisdiction is only the first hurdle. Even if diversity exists, the court must also have personal jurisdiction over the defendant. That means the defendant must have sufficient ties to the forum state such that it is fair and constitutional to haul them into court there. Melania Trump is now claiming that New York has no personal jurisdiction over her. According to her filings, she does not live in New York, does not conduct business there, and could not reasonably expect to be sued there. That claim is going to blow up in discovery. Where does she actually live? Where does she sleep? How many days does she spend at Trump Tower? Where does she shop? Where does she receive mail? Where does she attend social events? Where does she spend time with friends? Where does her child attend school? These are not gossip questions. These are jurisdictional facts. And once a defendant raises them, they become fair game for discovery. And here's the key point. Melania Trump cannot dodge discovery forever. By removing the case and filing substantive motions, she has begun to subject herself to the authority of the court. Depositions are coming. Document requests are coming. Jurisdictional discovery is coming. She cannot claim she is beyond the court's reach while simultaneously asking the court to rule in her favor. The law does not allow you to use jurisdiction as both a sword and a shield. And it gets worse for her. She has already filed a motion to dismiss, not just on service grounds, not just on jurisdictional grounds, but on the merits. That matters. When a defendant asks a court to rule on the substance of a case, they are often deemed to have waived certain jurisdictional objections. You cannot say, I'm not properly before this court, and in the same breath say, while I'm here, please dismiss this case because I should win. Courts call that waiver, and judges do not look kindly on it. Then there's the issue of truthfulness, or rather selective omission. In Melania Trump's motion to dismiss, her lawyers repeatedly described the case as arising from a single October 15th demand email asking Wolf to retract and apologize for allegedly defamatory statements. What they do not mention, not once, is that the email demanded $1 billion. A billion with a B. That omission is stunning. That billion-dollar demand is the entire reason Wolf went to court. It's the textbook definition of a chilling threat against speech, and yet her lawyers scrub it from the narrative. They mention that Wolf raised funds for his legal defense, repeating the $800,000 figure more than once, but they leave out the billion-dollar threat that prompted the lawsuit in the first place. That kind of selective storytelling does not play well with judges. And it raises an obvious question. If Melania Trump truly believes she was defamed, why hasn't she sued? She threatened Wolf. She threatened Hunter Biden. She set deadlines. She demanded apologies. And yet she never followed through. No defamation complaint, no damages claim, no jury demand, nothing. Instead, she runs from service, tries to move courts, and asks judges to dismiss cases brought against her. That looks less like confidence and more like fear. This is not how defamation victims behave. This is how people behave when they are terrified of discovery, when they know depositions would be dangerous, when they know documents might contradict their carefully curated public narrative, and when they know that once sworn testimony begins, there is no undo button. And that is where this case is heading, whether Melania Trump likes it or not. Now let's talk about service of process, because this is where Melania Trump's position really starts to collapse under its own weight. In her motion to dismiss, she argues that the case must be thrown out because she was never properly served. According to her lawyers, Wolf's team improperly attempted to serve a doorman at Trump Tower and improperly attempted to serve her counsel, neither of whom were authorized to accept service on her behalf. Therefore, she claims, the entire lawsuit should be dismissed. That argument might sound technical, but it borders on absurd when you look at the surrounding facts. Melania Trump's own lawyer sent a demand letter on October 15th explicitly stating that his firm represented her and instructing Wolf to direct all future correspondence regarding the dispute to him. That same lawyer then refused to accept service when Wolf did exactly what the letter told him to do. Courts do not reward that kind of gamesmanship. You cannot invite litigation communications through counsel and then claim service is invalid when the lawsuit actually arrives. Judges see this tactic all the time, and they despise it. Service of process is meant to ensure notice and fairness, not to create a shell game where wealthy defendants hide behind doormen and gatekeepers while insisting they cannot be found. And that raises another glaring issue. If Melania Trump truly lives in Palm Beach, Florida, as she claims, where exactly is she? Why haven't process servers been able to find her there? Why do Palm Beach locals say she is rarely, if ever, seen at Mar-a-Lago? Why does she appear far more frequently in New York? These questions are no longer rhetorical. They are now legally relevant. By asserting Florida domicile, Melania has opened the door to jurisdictional discovery. That means sworn testimony. That means documents. That means calendars, travel logs, residence records, and financial statements. It also means scrutiny of where her life is actually centered, not where she claims it is for litigation convenience. Judges don't rely on press releases. They rely on evidence. Then there is her due process argument, which may be the weakest of all. She claims that being sued in New York offends traditional notions of fair play and substantial justice because she did not purposefully avail herself of the privileges of doing business there. This argument is astonishing given her last name, her long-term residence at Trump Tower, her use of New York-based business entities, and her repeated public appearances in the state. Due process is not a magic phrase you recite to make lawsuits disappear. It is a balancing test. Courts look at contacts, conduct, foreseeability, and fairness. When you live, socialize, shop, and conduct personal and professional affairs in New York for years, it is entirely foreseeable that you could be sued there, especially when the allegedly defamatory statements concern events that took place in New York. And then comes the contradiction that may ultimately sink her motion. On the one hand, Melania Trump insists the court has no jurisdiction over her and that she was never properly served. On the other hand, she asks the same court to dismiss the case on the merits, declaring herself a defamation victim and demanding affirmative relief. You cannot have it both ways. The law simply does not allow that. If you are not properly before the court cannot rule in your favor. If the court can rule in your favor, then it has jurisdiction over you. That's the fork in the road, and Melania Trump has tried to walk down both paths at once. Courts treat that as waiver. Once you ask for substantive relief, you often lose the ability to argue that the court lacks authority over you, and that's before we even get to the most glaring omission in her filings. The billion-dollar demand, it is nowhere to be found. Not in the motion to dismiss, not in the jurisdictional arguments, not in the narrative summary. That omission is strategic, and it is telling. Her lawyers know that a demand for $1 billion over journalistic reporting looks abusive, punitive, and constitutionally suspect. They know it strengthens Wolf's anti-SLAPP arguments. They know it invites heightened judicial scrutiny, so they pretend it never happened. But it did happen. It is documented. It is in writing. And it is the entire reason this case exists. Wolf did not sue Melania Trump because he enjoys litigation. He sued because he was threatened with financial annihilation unless he stopped speaking. That is exactly what declaratory judgment actions are designed to address, and judges understand that. What we are watching now is not a confident litigant defending her reputation. We are watching a public figure attempting to avoid discovery at all costs, avoid depositions, avoid document production, avoid sworn testimony, avoid jurisdictional findings that contradict her preferred narrative, and above all, avoid a courtroom where facts matter more than intimidation. The irony is that every procedural maneuver she makes increases the likelihood of discovery rather than reducing it. By removing the case to federal court, she triggered stricter rules. By filing a motion to dismiss, she invited judicial scrutiny. By asserting Florida residency, she invited investigation. And by omitting the billion-dollar demand, she signaled vulnerability. This case is no longer just about defamation. It is about credibility, transparency, and the misuse of legal threats to suppress speech. And the longer Melania Trump runs from service, the worse it looks. Judges have tools for dealing with evasive defendants, and none of them work in her favor. What happens next is fairly predictable. Wolf's lawyers will argue waiver. They will seek jurisdictional discovery. They will challenge removal. They will push for depositions. And if the court denies the motion to dismiss, and there is a very real chance it will, this case proceeds into full discovery territory. And once that happens, there is no hiding. And this is where the case stops being a procedural chess match and starts becoming genuinely dangerous territory for Melania Trump, because once a court orders jurisdictional discovery, everything she has tried to avoid suddenly becomes unavoidable. Discovery is not storytelling. It is not PR. It is not a glossy documentary curated by Amazon executives. It is sworn testimony, compelled documents, and legally binding answers under penalty of perjury. Jurisdictional discovery alone can be expansive. Wolf's attorneys can seek records showing where Melania actually resides, how often she stays in New York versus Florida, where she receives mail, where her financial accounts are managed, where she votes, where her son attended school, where her medical providers are located, and where her personal staff operates. These are the exact factors courts use to determine domicile, and they are not optional once discovery is ordered. And if the court determines that Melania Trump misrepresented her residence to manufacture federal jurisdiction or to forum shop into Florida, that creates an entirely new problem. Judges take misstatements about jurisdiction extremely seriously. At best, it damages credibility. At worst, it opens the door to sanctions or adverse inferences. Courts are allowed to assume the worst when a party obstructs discovery or refuses to cooperate. This is why the fear of a Florida transfer looms so large. The defense strategy is clear. Remove the case from New York State Court, argue diversity jurisdiction, push for dismissal or transfer, hope the case lands in the Southern District of Florida, roll the dice on Judge Cannon. That is not speculation. That is textbook forum shopping, and federal judges are trained to spot it instantly. The problem is that forum shopping only works when the underlying facts support it, and the facts here are murky at best. Melania Trump has spent years blurring the lines between New York, Washington, and Florida. She appears when it suits her and disappears when accountability looms. That ambiguity is now her enemy. Then there is the substantive issue she is desperate to avoid, depositions about Epstein. Wolf has been very careful. He has not accused Melania Trump of committing crimes. He has not alleged she participated in Epstein's abuse. What he has done is ask questions about proximity, social circles, introductions, and timelines. Those questions are squarely within the realm of public interest journalism. Once discovery opens, Wolf's lawyers can ask about modeling agencies, travel history, parties attended, photos taken, introductions made, and communications exchanged. They can subpoena third parties. They can request documents. And every answer Melania gives becomes part of the official record. That is the nightmare scenario for someone whose public image relies on strict narrative control. Depositions are not scripted. There are no retakes. There are no edits. And inconsistencies matter. If her testimony contradicts public statements, filings, or past interviews, that becomes evidence, not opinion, evidence. This is also why the billion-dollar demand matters so much, even though her lawyers pretend it does not exist. A threat of that magnitude is not about protecting reputation. It is about silencing speech. Courts recognize that. Anti-SLAPP laws exist specifically to prevent powerful individuals from using the threat of ruinous litigation to suppress journalists. By omitting the billion-dollar demand from her filings, Melania's legal team is trying to reframe the case as a routine defamation dispute, but the record tells a different story. The demand letter exists, the number exists, and the chilling effect is obvious. That omission will not go unnoticed. And let's be clear about something else. Melania Trump has not actually sued Michael Wolff for defamation. Despite all the threats, despite the deadlines, despite the billion-dollar number, she has never filed her own lawsuit. That silence speaks volumes. If she truly believed the statements were false and defamatory, She could have filed suit and forced Wolf to defend them in court. She didn't. Instead, she threatened. And when Wolf called her bluff and went to court first, she ran. Running works in politics. It does not work in litigation. Judges do not care about status. They do not care about documentaries. They do not care about who your husband is. They care about procedure, truth, and fairness. And right now, Melania Trump's strategy looks less like a defense and more like an attempt to exhaust the system until someone gives up. That is unlikely to succeed. What happens next is critical. If the court denies her motion to dismiss, discovery begins. If the court orders jurisdictional discovery, she must participate. If the court finds waiver, her jurisdictional defenses weaken. And if the case remains in New York, the leverage shifts decisively toward Wolf. At that point, Melania Trump faces a choice she has been avoiding since October: answer questions under oath or escalate her avoidance and risk judicial consequences. There is no third option, and this is why she is panicking. Not because of headlines, not because of social media chatter, but because the legal system has finally closed in around her, and the tools she has relied on for years, threats, silence, delay, intimidation, no longer work. This case is no longer about what Michael Wolff said. It is about what Melania Trump does next. And the longer this drags on, the worse it gets for her, because delay does not freeze the record. It expands it. Every new filing, every contradiction, every omission becomes another data point that Wolff's legal team can exploit. Courts do not look kindly on litigants who attempt to game procedure while simultaneously asking for relief. That is especially true when the litigant is a public figure attempting to suppress reporting on a matter of undeniable public interest. There is also a fundamental contradiction at the heart of Melania Trump's strategy that judges are trained to sniff out immediately. On one hand, she claims she has suffered devastating reputational harm from Wolff's statements. On the other hand, she refuses to file an affirmative defamation suit that would allow her to prove that harm, quantify damages, and clear her name through evidence. You cannot claim catastrophic injury while refusing the very process designed to adjudicate it. That contradiction will matter if the court reaches the merits, but it already matters at the procedural stage. When someone claims defamation but avoids discovery, courts infer fear of what discovery will reveal. That inference is not political, it is legal, and it is powerful. There is also the First Amendment overlay, which looms over this entire case like a storm cloud. Wolff is not a random internet commenter. He is a journalist with a documented history of reporting on the Trump orbit, including direct interviews with Epstein himself. Courts give journalists wide latitude when reporting on public figures, especially when the reporting concerns relationships, power networks, and potential influence. The standard for defamation in that context is extremely high. Actual malice is required. Knowledge of falsity, reckless disregard for the truth. Nothing Melania Trump has filed so far comes close to meeting that standard. Assertions are not evidence. Outrage is not proof. Threat letters are not findings of fact. If anything, her legal posture reinforces Wolff's argument that this was an attempt to chill speech rather than correct falsehoods. And then there is the optics problem, which is not legally determinative, but absolutely influences how judges perceive credibility. While she claims to be a private individual unfairly dragged into controversy, she is simultaneously promoting a lavish, heavily funded documentary about her life, her story, her truth. You do not get to demand public attention on your terms and then claim immunity from scrutiny when journalists ask uncomfortable questions. Courts understand that tension. Public figure status is not erased by selective silence. If you step into the public arena to rehabilitate your image, you reopen the door to examination. This is why the timing of everything matters. The documentary rollout, the sudden burst of promotional activity, the frantic late-night filings, the sudden insistence on Florida residency, the removal to federal court. None of this looks organic. It looks reactive. It looks like someone trying to outrun a process that has already caught up to them. And that is the cruel irony of this case. If Melania Trump had done nothing, this might have faded. If she had issued a calm denial and moved on, it likely would not have escalated. But by threatening a billion-dollar lawsuit, she elevated the issue. By refusing to follow through, she undermined her own credibility. By dodging service, she antagonized the courts, and by attempting to forum shop, she alerted judges to her strategy. What people often misunderstand about litigation is that it is not about winning arguments in press releases. It is about surviving procedure. And procedure is unforgiving. Deadlines are real. Orders are binding. Discovery is compulsory. Judges have immense discretion. And once they suspect manipulation, that discretion is rarely exercised in the manipulator's favor.